Imagine trying to prove a crime where the weapon isn't, a physical object, but a locked bank account and like a whisper campaign about your sanity.
Right, which is incredibly difficult to do because when we hear the words domestic violence, most of our brains probably jump straight to a very specific physical image.
Exactly. A bruise, a broken bone, a physical altercation. And traditionally, I mean, that is exactly how the legal system has viewed it, too.
Yeah, if there wasn't a visible mark, there just wasn't a crime.
But today is Tuesday, June 23, 2026, and we are taking a deep dive into a stack of legal documents that, well, it completely shatters that traditional framework.
It really does tear it down.
Today we're looking at the Domestic Violence Prevention and Protection Act from 2013 and the Domestic Violence Prevention and Protection Rules from 2016. These were compiled by the Sindh Judicial Academy in Karachi, Pakistan.
And these documents are fascinating to look at together.
Yeah, and our mission today is to explore how this specific legal framework attempts to structurally dismantle domestic violence, like moving from the abstract definitions of abuse to the literal physical safety nets put in place to protect people.
Which is a massive undertaking.
It is. Okay, let's
Yeah.
unpack this because most people think of domestic violence solely as physical harm.
Hmm.
But this specific legislation goes to incredible lengths to criminalize the psychological and financial tactics that abusers use to build invisible cages around their victims.
It really does. And I think to grasp how this law actually functions on the ground, we have to look at how it redefines who and what is involved in domestic violence.
Right, because it's not just husband and wife.
Exactly. The legislation starts by tearing down that exact assumption. It broadens the definition of a domestic relationship to include consanguinity, which, simply means blood relations.
Okay.
But along with marriage and adoption, it even covers people who just live together or have lived together in a shared household.
Wow, so it's an acknowledgement that abuse can come from siblings or in-laws or just extended family living under one roof.
Exactly. It covers the whole household dynamic.
That makes a lot of sense. But I think the part that really shifts the paradigm is Section 5 of the Act, which defines what actually constitutes domestic violence.
Yeah, that section is incredibly detailed.
It is. It lists physical abuse, obviously,
Hmm.
but then it spends a massive amount of text defining emotional, psychological, and verbal abuse.
And it gets highly specific.
Super specific. We're talking about a pattern of degrading conduct. It lists obsessive possessiveness or jealousy that invades a victim's privacy and liberty.
Which is huge to have in writing.
Right. It even names threats of malicious prosecution, threats of divorce, or like baselessly blaming a spouse of immorality.
What's fascinating here is how the text targets highly specific, localized tactics of control.
Yeah.
For instance, the law explicitly criminalizes imputing insanity or citing barrenness of a spouse with the intention to marry again.
I found that inclusion of barrenness incredibly specific. Like, why is that explicitly named in a legal statute alongside things like physical assault?
Well, because the drafters of the law recognized how social stigma operates as a weapon.
Oh, I see.
Yeah, in many communities, if an abuser wants out of a marriage or wants to take another wife, falsely labeling the first wife as insane or barren isn't just a casual insult.
Right. It's a tool.
Exactly. It's a calculated tactic designed to destroy her social standing, isolate her from community support, and essentially justify abandoning her.
Wow.
And the law names this exact tactic and makes it a crime. Furthermore, the act criminalizes economic abuse, which means depriving the victim of financial resources they are legally or ordinarily entitled to.
So taking away their money.
Yes. It also criminalizes stalking and sexual abuse, which explicitly includes compelling a wife to cohabit with someone else.
It's like the law is finally catching up to the reality that a cage isn't always made of iron bars. Sometimes it's made of controlled bank accounts, weaponized jealousy, and threats of divorce.
That is a perfect way to put it. And it's not just in theory either. The law actually attaches concrete, quantifiable punishments to these non-physical forms of abuse.
Right. Section 6 lays out the penalties.
Yeah, so if someone commits emotional and psychological abuse, they face a minimum of 6 months in prison or a fine of at least 10,000 rupees.
Okay, so real consequences.
Exactly. Stalking carries a minimum of 1 year in prison or a 20,000 rupee fine. Sexual abuse carries a minimum of 2 years or 50,000 rupees.
So by attaching hard numbers and mandatory jail time to these actions, the legal system is basically forcing society to view psychological and economic harm as tangible, measurable crimes.
Right, rather than brushing them off as just bad behavior or, a private family matter.
It pulls that behavior out of the shadows and puts a literal price tag and a jail sentence on it. So that establishes the crime.
Yes.
But identifying the abuse is only half the battle. How does the legal system actually pry the doors open for the victim?
That is where the architecture of protection comes in.
Right. We need to look at the immediate legal remedies available. And from what I read, this act is built around speed.
Speed is essential.
The document mandates that once a petition is filed, the court has to fix a hearing within 7 days, and they are required to dispose of the entire case within 90 days.
That timeline is absolutely critical because, well, in domestic violence situations, prolonged legal battles often result in the victim abandoning the case.
Oh, because of intimidation.
Intimidation or just a total lack of resources to keep fighting.
Mhm.
So the court is given a toolkit of immediate interventions to prevent that.
Like the protection orders.
Exactly. These can legally ban the abuser from communicating with the victim in any form at all, electronic, written, personal, you name it.
Right.
It can bar them from entering the victim's workplace or, if the victim is a child, their school.
And reading through the toolkit, there's the residence order. To me, this seems like one of the most radical pieces of this entire legal framework.
Radical is definitely the right word for it.
Section 9 of the Act states that the aggrieved person cannot be evicted from the household, even if they have no legal title, ownership, or beneficial interest in the property.
Right, because property law usually favors the person whose name is on the deed.
Exactly.
But this act flips that script entirely. It says that physical safety trumps property rights.
Right, so let's walk through how that works. If a woman is being abused, and the house is entirely in her husband's name, or even his family's name, the court can issue a residence order that allows her to stay in that house.
Yes.
The court can actually legally restrain the abuser or his relatives from entering their own property.
It's a massive shift in power.
And if the situation is too volatile and staying isn't safe, the court can force the abuser to pay rent to secure alternative accommodation for the victim.
Exactly. And that ties directly back to dismantling the economic abuse we talked about earlier.
Oh, right.
Because abusers often use financial control to keep victims trapped. To counter this, the court can issue monetary relief orders.
To cover things like medical bills.
Medical expenses, the loss of earnings, and provide compensation for that economic control.
And if the abuser refuses to pay.
The legal framework allows the court to bypass them entirely. They can go straight to the abuser's employer and direct the employer to garnish the wages.
Wow. Paying the victim directly before the abuser even sees the paycheck.
Exactly.
Okay, but let's be real. I have to push back here.
Go for it.
A judge sitting in a courtroom miles away signs a piece of paper telling an abuser to stay away, or a residence order telling them to leave their own house. How does a piece of paper actually stop someone in the heat of the moment?
It's a very valid concern.
Because if someone is prone to violent, controlling behavior, a court order might not mean much when the front door closes.
That is the fundamental vulnerability of almost every legal system in the world. A law is just ink on paper without an enforcement mechanism.
Right.
And that brings us directly to why we are looking at two documents today. The 2013 Act laid out the ideals, but it needed muscle.
The 2016 rules.
Yes. That is exactly why the 2016 rules were drafted, to create the physical, human infrastructure required to enforce the ink on the paper and answer your exact concern.
So we move from the courtroom decrees to the actual people hired to enforce them in the community.
Precisely.
Looking at the 2016 rules, they established a massive oversight body, a 16-member provincial commission on domestic violence. And they clearly want serious expertise here.
Absolutely.
Because civil society members on this commission are required to have at least 10 years of experience working on women's rights. But, I mean, the big picture strategy doesn't stop a fist. The real day-to-day enforcement happens at the district level.
Correct. The rules mandate that every district gets a protection officer. Now, it's really important to understand the weight of this role.
Okay.
This isn't just an entry-level administrative job. The document specifies this is a gazetted officer at a BPS 17 rank.
Which essentially means what in practice?
It means this is a senior management level role. They have the actual bureaucratic muscle and authority to get things done within the government system.
That makes a big difference.
It really does. The rules also explicitly state a preference for female officers in this role. Their job is to be the central node of the crisis response.
So they file the paperwork.
Yeah, when a crisis happens, they file the official domestic incident reports, known as Form 1, but they are also responsible for getting the victim to a safe shelter, ensuring they have legal aid, and coordinating medical exams.
But they don't do it alone. And here's where it gets really interesting. The rules mandate the creation of district protection committees.
Yes, the committees are vital.
When I read the makeup of these committees, it looks less like a traditional police response and more like an Avengers Assemble situation for social work.
That analogy actually fits perfectly when you look at the required roster.
You've got a social welfare officer, a medical practitioner, a psychologist, a psychosocial worker, a court official, and a female police officer.
And not just any police officer.
Right. It specifies someone not below the rank of deputy superintendent of police or sub-inspector, so we were talking about senior command, plus 2 civil society members.
It's a huge team.
They all team up to surround the victim with a multi-layered shield. Why is it so crucial to have all these different professions in one room?
Well, because traditional police-only responses often fail victims of domestic violence.
How so?
If you just send a police officer, sure, they can make an arrest, but what happens to the victim that night? They have no money, no housing, and untreated trauma.
Oh, wow, yeah.
This multidisciplinary approach recognizes that escaping domestic violence requires all of these systems to act simultaneously.
You need everything at once.
Exactly. You need immediate housing, you need mental health support, you need a doctor for injuries, and you need senior law enforcement to physically enforce those court orders.
Which brings up a critical bottleneck that the 2016 rules actually address head-on. Let's talk about Rule 40 regarding medical facilities.
This is a game changer.
Traditionally, if a victim of violence goes to a hospital, medical facilities often hesitate or outright refuse to treat them unless a formal police report, an FIR, has already been filed.
Right, it becomes this impossible bureaucratic loop.
You can't get medical help without the police, but you're too injured or maybe too terrified of your abuser to go to the police station first.
That loop is exactly what Rule 40 cuts right through.
Thank goodness.
It legally mandates that a medical facility cannot refuse treatment to an aggrieved person just because they haven't lodged a police report. The hospital's priority has to be medical care, not bureaucratic paperwork.
That makes total sense.
And in fact, if there is no police report, the person in charge of the medical facility is legally obligated to create a domestic incident report right there at the hospital.
Wait, really?
Yes, and then forward it directly to the local protection officer.
So it effectively turns doctors and nurses into an active, mandatory entry point to the safety net. You don't have to find the protection officer. The hospital brings the protection officer to you. The system is incredibly comprehensive.
It is very thorough.
But, well, as we read further into the 2016 rules, we hit a section that completely shifts the tone.
Yes, the alternative route.
Right. We've seen the heavy hand of the law, the wage garnishing, the multidisciplinary committees, the strict hospital mandates. But there's an alternative route outlined in Section 8 of the Act, fleshed out in the rules, that is highly specific and honestly somewhat controversial.
It definitely sparks debate.
It's the provision for mandatory counseling and settlement.
Yes. The law allows the court or the protection officer to appoint a counselor who, again, should preferably be a woman.
Okay.
This counselor convenes a meeting with both the victim and the abuser.
I have to ask, isn't mediation in a domestic violence situation incredibly risky?
It is a profound risk.
Doesn't putting the victim right back in the room with the person who harmed them completely undermine all that protection we just talked about? You have psychologists and senior police officers shielding the victim, and then you put them in a room with the abuser to try and work it out.
It absolutely walks a delicate tightrope. But if we connect this to the bigger picture, we have to look at the drafter's logic and how the law attempts to neutralize the risk of mediation.
Okay, how do they do that?
First, look at the strict boundaries set by Rule 37, specifically Sub-Rule 5. It establishes an absolute prohibition.
Oh, I remember this part.
It states that the respondent shall not be allowed to plead any counter-justification for the alleged act of domestic violence.
So the abuser can't sit in that counseling session and say, well, I hit her because she disrespected me, or I locked her out of the bank account because she spends too much.
Exactly. The law strips the abuser of their justifications before the session even begins.
That's a huge boundary.
It is. The counselor's job is not to play referee and figure out who is at fault. The rules explicitly state that the goal of counseling is strictly to get an undertaking.
An undertaking.
Yeah, which is a formal written assurance from the abuser that the violence will not be repeated, and to formulate a settlement that redresses the victim's grievances.
And if they don't agree?
If the abuser refuses to sign it, or if the counseling fails to reach a safe agreement, the process ends and the case goes right back to the court for standard prosecution.
It sounds less like traditional couples therapy and more like The legal system, sitting the abuser down and demanding a behavioral contract.
That's a good way to look at it.
But why even offer this route? Why not just rely on the courts and prosecute every single time?
Because the drafters are operating within a complex cultural reality.
I see.
In many contexts, victims of domestic violence do not necessarily want their spouse criminally convicted and thrown in jail.
They just want it to stop.
Right. The drafters recognize that standard criminalization can sometimes trigger unintended, devastating consequences.
Like what?
Well, jailing a husband might lead to intense retaliation from the extended family, social ostracization of the wife, or total financial ruin for her and her children. Many victims simply want the abuse to stop, and they want their financial security and housing maintained.
So this counseling clause acts as a pragmatic tool. It gives the system a mechanism to leverage an official court-backed undertaking to achieve peace in the household,
Yes.
without immediately triggering the nuclear option of a criminal conviction, unless, of course, the abuser violates that peace.
That's the underlying logic. It provides the victim with a degree of agency to choose the legal outcome that actually makes them safest in their specific context, which
Okay.
might not always be putting their partner in a prison cell.
It acknowledges that justice doesn't always look like a conviction. Sometimes it looks like a guaranteed safe home and an enforceable legal boundary.
Perfectly said.
So what does this all mean? When we look at the 2013 Act and the 2016 rules together, what is the ultimate takeaway for you listening to this deep dive?
There's a lot to consider.
It means that modern legal frameworks are finally understanding that domestic violence is not just a momentary loss of temper or a physical altercation. It is a calculated ecosystem of control.
Yeah.
It's isolation, it's economic deprivation, it's psychological warfare.
Right.
And because the abuse operates as a complex ecosystem, it requires an equally complex ecosystem of doctors, police, courts, and social workers to dismantle it.
You really can't just send one officer.
No, you need hospitals legally bound to report, courts that can redirect paychecks, multidisciplinary committees, and laws that recognize weaponizing social stigma is an act of violence.
That is the formidable power of this framework on paper. But, I want to leave you with a final thought to mull over, something that isn't really solved by the text itself.
Okay, what is it?
This legal framework, compiled by the Sindh Judicial Academy, is incredibly robust. It offers